Imagine finding a strategy that, well, claims it could help you avoid maybe 95, even 99% of all your traffic tickets. Speeding, expired registration, parking, you name it. It's quite a claim. And today we're really diving into the details of how this very unconventional approach is supposed to work.
Yeah, we're pulling back the curtain on a really unique way to handle traffic court. It's all based on some fascinating insights from an audio clip featuring a former probation officer. Now, just a heads up for everyone listening, the strategies we're discussing, they're presented purely as the claims from our source material. This isn't legal advice. Seriously, trying these tactics in a real court could have, well, unpredictable and possibly serious legal consequences. So, keep that in mind.
Absolutely. Our mission here really is just to meticulously unpack the steps, the details, and the thinking behind what's presented in our source. It's an audio excerpt called MGTOW Men Part 1, How to Get Out of 99% of All Traffic Tickets.mp3. And just for clarity, MGTOW stands for Men Going Their Own Way. It's a philosophy where some men advocate for disengaging from certain societal institutions they see as biased. Now, while the source comes from that specific background, we're focused only on impartially unpacking its claims about traffic court tactics. We're not endorsing the wider MGTOW view or, its characterizations.
Right. And the core idea from this source is really bold. It basically says you are the one in charge in the courtroom, if you choose to be, that is, which is a stark contrast to how the source sees most people acting. It uses some pretty strong language, calling the typical approach sort of pathetic, groveling wusses. Okay, so let's set the stage a bit. The basic idea here is it's like seeing the courtroom completely differently. Yeah. The strategy isn't about just defending yourself passively. It's aggressive, like bringing your offense onto the field in a football game.
Yeah.
That's the analogy they use.
Yeah, and the person laying this all out, they talk about their background. They say they were a probation officer down in Manatee County, Florida, for 3 years. And they claim this experience gave them this unique insight, let them, in their words, run all over the people that were working there in court.
Okay. So with that kind of background claimed, what's the absolute first thing you need to do before you even set foot in the courtroom, according to this method?
Well, the source is really insistent on this crucial bit of prep work. You absolutely must get the full names, both the judge and the prosecutor, before the arraignment.
Full names, okay. How do you get those?
Usually you can just call the court or maybe check their website. It's generally available information. But the source really hammers this home, quote, "Do not fail in getting this. It's emphatic."
All right, so you've done the homework, got the names, you're in court, they call your case. Normally you'd hear guilty or not guilty, how do you plead? But here, this is where things get, well, really interesting.
Yeah, this is the pivot point. The strategy calls for an immediate, aggressive countermove. First, you demand the judge's full name on and for the record.
How exactly? What do you say?
The script is, "I object on and for the record. Give me your name, judge, on the record. What is your name?" Now, if the judge tries to dodge it or only gives the last name, say, you immediately bring up a case, U.S. versus Tweel. That's T-W-E-E-L.
Okay, U.S. versus Tweel. And why that case?
The source claims this Supreme Court decision means the judge is bound by their oath of office to answer fully. The specific wording they suggest is, according to U.S. versus Tweel, by which Supreme Court decision, you are bound according to your oath in office on and for the record. Then you add, let the record show that absence of or negative response answers in the affirmative. Do you understand?
Oh, that's specific.
Very. And then you do the exact same thing with the prosecutor. You state their name if you have it, like, is your name Kendra Lynette White? Answer. If they refuse or give a partial answer, you then declare, I accept your oaths of office as binding contracts.
Okay. And the tone here is important.
Crucial. The source stresses you need to be aggressive. Do not stop talking. They claim the court officials will try to race past you because supposedly they know they're in trouble.
So after you've made this very assertive opening play, what's the next demand? The source mentioned something key here.
Yes, the next big demand is for what the source calls the charging instrument.
Charging instrument. What is that exactly?
Okay, so it's defined in the source as a document needing 2 signatures, not just one.
2 signatures. Whose?
The police officer who issued the ticket and a judge or a notary. That's what supposedly confirms the charges are actually being filed. And the source clarifies this is about civil damages, not really a crime in the way we usually think of it.
Okay, civil damages. And why is this instrument so vital to the strategy?
Because, as the source puts it very directly, if they don't have a charging instrument, you have nothing to plead to. Nothing.
Nothing to plead to.
Right. And the source argues that courts usually won't have it.
Why not?
Just practical reasons, supposedly. Think about it. Police officers writing tickets all day. Do they have time to drive to the courthouse for every single ticket to get a judge or notary signature? The source claims it's just too costly, too time-consuming, so they state 95 to 99% of time, they will never have it.
95 to 99%.
Mm-hmm.
That's astounding. It's true. So, okay, how does the source say you actually demand this charging instrument in court?
You have to be persistent. The phrasing provided is, objection. I demand to see the charging instrument or you will dismiss the case with prejudice. Then you continue, I will not go any further. There's nothing to plead to. You will present the charging instrument or you will dismiss the case with prejudice. I'm making that demand to you, Judge, respectfully.
With prejudice. What does that mean in this context?
According to the source, it means you will not charge me again for the same alleged offense. It's final.
Okay. And the source mentions that the judge might try to sidestep this demand. How do you handle that?
Yeah, absolutely. They warn the judge might try to dodge it, maybe suggest a new court date or say, we'll discuss that later, or even try to claim the ticket as the charging instrument.
Which the source says it isn't.
Right. The advice is crystal clear. Keep repeating the demand. Don't give in for anything. These are just distractions, according to the material.
So what if you keep demanding it and the judge keeps refusing? The source talks about a point of dishonor.
Yes. If they refuse, say, 3 times, the source advises an escalation. You state, objection, ma'am, or sir, presumably, you will not run this courtroom on assumptions, ceremonies, or your entitlement. You continue.
Okay.
You will present the paperwork. You will perform. You and the prosecutor will perform. If you can't perform, you will dismiss the case with prejudice. And then, if I'm required to perform, you are required to perform.
That's incredibly direct.
The source claims this specific wording will scare them badly. That's the quote.
Okay, this is wild. What if, even after that, the judge just ignores you and tries to enter a plea for you anyway? Does the source have an answer for that?
It does. This is what they call the judge volunteering as lawyer scenario. It sounds bizarre, but yeah. If the judge pleads for you, ignoring your demands, you're supposed to immediately say, thank you, judge, for volunteering to be my lawyer.
Seriously?
Seriously. Then you add, I can now waive all fees, court costs, and fines with surety. It is a contract, sir. Again, I thank you for having presenting a contract, and I accept it fully.
A contract. How does that work?
The claim is, this somehow creates a contract that stops them from charging you money. The ticket might still hit your record, but no fines or fees. And the source suggests you could then potentially sue them for violation of contract through appeals. It's a complex claim.
This whole thing seems to hinge on a very specific view of the law. The source talks about different types, right?
Right.
Constitutional versus administrative.
Exactly. That's a key distinction for them. The initial move's demanding names, citing U.S. versus Tweel, that's all designed to force the court into what the source calls constitutional law, specifically equity law. And under that, they claim, the court would then need to produce a damaged party. That's apparently for part 2 of their discussion.
Okay, so that's one type. What's the other?
The other is administrative law.
Yeah.
And the source describes this very bluntly, like, I'm your dad, you are my son, and you will do whatever I say. Essentially, You're guilty until proven innocent, and the source is very clear. You do not want to go via administrative court.
Right. So what happens if, despite trying all these tactics, you somehow end up getting pushed towards an administrative hearing or date anyway?
If that happens, the source says you need to act immediately, like lightning fast. You must loudly assert those constitutional points. Again, the name demand, the U.S. versus Tweel citation, before the prosecutor can even start. Otherwise, the source warns, it'll be a lightning-quick trial, and you lose their advice. You must scream, you must object real loudly.
It really emphasizes a total change in attitude, doesn't it?
Yeah.
Throwing out the whole yes sir, no sir deference.
Completely. Assertiveness is everything here. The source argues these actions aren't contempt of court, they're standing up for your rights. And the argument is, courts don't actually recognize rights unless you actively, forcefully assert them.
What if the judge threatens you for doing this, like with contempt?
The suggested response is direct confrontation. Judge, are you threatening me? Are you threatening my right to defend myself in this courtroom? Are you threatening me? Then I will put that on the record, sir. If you are threatening me, are you doing it? The source claims the judge will back down immediately.
And there's an anecdote about extra guards.
Yeah, the speaker tells a story about their own ticket, claiming 7 extra guards showed up. They interpret this as intimidation. Why? Because in their view, court staff are just used to going out on the football field with their offense and just running down the field and scoring without nobody else on the field.
They don't pull any punches describing judges either.
No, the language is incredibly strong, calls them a bunch of lying, sleazy scuzzbags who will do anything to win. Again, that's the source's phrasing, not ours. The whole strategy, ultimately, is designed to put the court on the back foot, drive them into their own end zone, make them worry about losing money, and maybe worry about other people seeing this method.
Wow. Okay, so we've just walked through a really specific, very, very assertive strategy for trying to challenge traffic tickets, all based on this one source. Demanding names, citing Supreme Court cases, insisting on this charging instrument, understanding the difference between constitutional and administrative law as they see it. It's definitely an approach that flies in the face of how most people experience court.
It really does. This deep dive shows a perspective where the courtroom is seen almost like a battlefield, and asserting very specific bits of legal knowledge plus this relentless, almost aggressive demeanor are presented as the keys to, well, winning and avoiding those fines and points.
So after hearing all that, what should you, the listener, take away from this?
Well, I think this information, coming directly from the source material, it brings up a pretty interesting question, doesn't it? We live in a time where information about legal stuff is everywhere, online, but what does it really mean to understand and assert your rights? And maybe how much of what we think of as authority actually relies on people not being assertive, or maybe just not knowing these kinds of arguments exist. It's definitely something to think about long after we finish this deep dive.